Yes, sir, Your Honor.
Would you please stand and raise your right hand as best you can for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, go ahead and sit back down. And are you Brett Mitchell Tenhopen?
Yes, sir.
Am I pronouncing that right?
Tenhopen?
Tenhopen.
Yep.
Okay. All right, Mr. Tenhopen, a guilty plea hearing is an important event because by pleading guilty, you waive constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. I'm happy to answer it. If you need a minute to talk to your attorney, you just let us know. We're happy to give you that time. Do you understand those things?
Yes, sir.
Okay, I have to advise you the maximum penalty that you could face for the charge to which you'd be pleading. Domestic violence third offense is a felony crime. It is punishable by a maximum of 5 years in prison and or a $5,000 fine. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere?
I'm on probation in Emmett, sir.
For felony or misdemeanor?
OWI, sir.
Okay. And so do you understand that, and you were on probation at the time of this incident?
Yes, sir.
So do you understand that by pleading guilty to this matter, that may very well constitute a violation of your probation in Emmett County then? Okay. All right, but counsel, you're unaware of any consecutive sentencing that would apply here?
No, Your Honor.
Okay, Ms. Goodrich.
I agree.
Okay. All right, and
So that means whatever happens in Emmett will be run concurrent?
yeah, probation violations are not consecutive, but bond violations are. So if you were on, or parole too, if you were on parole or bond, that could be consecutive,
Thank God.
but probation would be concurrent.
Thank you.
All right, and Mr. Tenhopen, do you understand if you enter a plea, you give up the rights that you would have had at trial and you won't have a trial at all?
Yes, sir.
I want to remind you the most important of those trial rights. You would have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You'd have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order those witnesses to show up. And you'd have the right to testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
Yes, sir.
Do you have any questions for me or Mr. Fragel about any of those rights?
No, sir.
Do you wish to give up those rights and enter this plea here today?
Yes, sir.
If I accept that plea, you give up any claim that this plea was caused by promises that aren't put on the record or that it was caused by any threats. Do you understand that?
Yes.
Also, when you enter a plea, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do that by filing an application, but the types of issues you could raise on an appeal by application are very limited, much more limited than if you were convicted after a trial. Do you understand that?
Yes, sir.
The plea agreement provides in exchange for your plea of guilty to count 1, domestic violence third, prosecutor will dismiss the habitual notice. And you understand the terms of that plea agreement?
Yes, sir.
Mr. Fragel, is that a full, fair, and accurate statement of its terms?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Tenhopen, has anybody promised you anything else to get your plea guilty?
No, sir.
Has anybody threatened you to make you plead guilty?
No, sir.
Is it your own free choice to enter that plea?
Yes, sir.
Knowing all this, how do you wish to plead to the charge of domestic violence third offense?
Guilty.
So, Mr. Tenhopen, back on May 27th of this year, 2026, were you in Shabboan County?
I was.
And were you with a Carrie Lee Grant?
Yes, sir.
And were you in a dating relationship with Miss Grant at that time?
Yes, sir.
Okay, did you have an argument with her?
I did.
And during that argument, did you assault her?
I did grab her by the face and I yelled at her. Yes, sir.
Okay, and when you grabbed her by the face, did she give you permission to do that?
Probably not.
Okay.
No, sir.
Yeah. And would you understand somebody in her shoes would find that to be a harmful or offensive touching?
Yes.
Okay. And at that time, did you have a prior conviction for domestic assault? Looks like back in May of 2002 in the 60th District Court.
I believe so.
And September 2002 in the 60th District Court.
And there's a couple of them I have on my brother that I remember. Yes.
Okay.
On my brother. So yes.
All right. And Ms. Goodrich, you don't need me to go through all of these, do you?
No.
Okay. Mr. Tenhopen, you've had a chance to review the charging document. Did you have any basis to challenge any of the listed prior convictions in the third offense notice?
Not that I can see, no.
Okay. All right, Mr. Fragel, are you satisfied with the factual basis?
Yes, just one more question.
Yes.
Lieutenant Holman, we gave you a copy of the felony information prior to today's hearing, correct?
Yes,
You had a chance to read that,
yes,
and you have your GED and understand how to
I
read.
do, yes, sir.
What were the questions?
Okay, and you're satisfied with the factual basis? Ms.
Yes.
Goodrich, are you satisfied as well?
Yes.
Mr. Fragel, are you aware of any other promises, threats, or inducements for this plea?
No, Your Honor.
And in your judgment, do you believe I fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Ms. Goodrich, as to both questions, do you agree?
I agree.
Mr. Tenhopen, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you are guilty of that offense. So I hereby accept your plea. Someone from the probation department will be talking with you so they can do an updated pre-sentence report for me before I sentence you here. And we'll schedule sentencing then. Mr. Fragel, how does October 13 look for you for an in-person
That
sentencing?
will be fine, Your Honor.
And could you do that, say, at 11:20 a.m.?
Yes.
Anything further from the defense?
Yes, Your Honor. I spoke with the prosecutor prior to lunch about lifting the no contact provision with the victim. And I believe the victim consents to the contact. So we would ask the court to lift that at least for telephonic and email purposes.
We understand he would still be incarcerated, but we have no objection to lifting that.
Is he on no bond on, say, the probation matter or something? Or is there a bond that he could post and he just hasn't?
This the probation holds from the county.
There's a probation. Well, and I mean, he entered a plea at this, he entered a plea is no longer cloaked with the presumption of innocence. So Ms. Goodrich, you have no objection to removing that as long as there's, as long as he's incarcerated?
Correct.
Okay. Well, I'll enter an order revoking his bond in this file, just so I have a guarantee that he's not going to be out. And I'll also order that the no contact provision is lifted. Okay, anything further from the people,
No, Your Honor, thank you.
from the defense?
No, thank you, Your Honor.
Okay, we'll see you mid-October, Mr. Kennedy.
Okay.